All right, today we are going to unlock a seriously powerful tool, one that every parent and every student has a right to. We're talking about the master key to school records. Have you ever heard that one before? It's like hitting a brick wall, right? This vague privacy thing that just seems designed to keep you out. But what if I told you the very law they're citing is actually meant to let you in? That's the big secret right there. The law, which is called FERPA, isn't a lock to keep you away from your kids' information. Nope, it's a set of keys, and they're designed specifically to give you access and control. So today, we're going to put those keys right in your hand. Okay, so first things first. Before we can use these keys, we have to know which doors they actually open. So what in the world is an education record, according to the law? It's actually a really simple two-part test. Number one, is the record directly related to a student? And number two, is it maintained by the school? Now that word maintained is absolutely crucial. It basically means the school has decided to keep it as part of its official system. Let's break this down to make it super clear. On the left, you've got the obvious stuff, right? Grades, discipline files, special ed evaluations, all that. And yeah, even emails can count if the school's keeping them as part of that student's file. But look at the right side. These exceptions are just as important. A teacher's private notes that they don't share with anyone, that's not a record. Records from a school's separate police or security department, also not an education record. Knowing this difference is a total game changer. Okay, so now we know what a record is, let's get to the good stuff, the 4 essential tools that FERPA gives you. Think of this as your personal toolkit. Your rights really just boil down to 4 simple actions. You have the right to see the records, you have the right to fix them if they're wrong, you have the right to control who else gets to see them, and you have the right to complain if the school doesn't follow the rules. Inspect, amend, consent, and complain. That is the core of your power. Now, I want you to remember this number, 45. Once you put in a written request to see your child's records, the school has a maximum of 45 days to show them to you. Not whenever they get around to it, 45 days. That's the law. And that clock starts ticking the second they get your request. So who actually gets to use these keys? Well, for any student in K through 12 who is under 18, the rights belong to the parents. And listen, this is really important. That means both parents, whether they're custodial or not, have equal rights, unless a court has issued an order that specifically takes those rights away. Then, once a student turns 18 or starts college, those rights transfer directly to them. They're now what's called an eligible student. Now, you know it wouldn't be a law if there weren't some exceptions. So while your consent is the default rule, there are definitely specific times when a school is allowed to share information without asking you first. This chart gives you a quick look at the most common reasons. The biggest piece of the pie there is for school officials who have a legitimate educational reason to look at the records. Other big ones include sending records to a new school, dealing with a health or safety emergency, responding to a subpoena, and releasing something called directory information. Okay, let's talk about directory information because this one is a really big deal. This is all the basic stuff, name, address, phone number, that schools can just hand out unless you specifically tell them not to. They have to give you a heads up and a chance to opt out. Honestly, if you have any safety or privacy concerns at all, filling out that opt-out form is one of the fastest and most powerful privacy upgrades you can make. All right, here is a pro-level tool that most people have absolutely never heard of. You see, schools are required by law to keep a log of every single time they've shared your students' records, who they shared them with, and why. It's called the disclosure log, and asking for it is like asking to see the security tapes. It tells you exactly who's been in the file. So we've covered all the theory. Now let's get super practical. Here is your step-by-step playbook for actually going out and getting the records. Here it is, simple and sweet. 1. Put your request in writing and be broad. Ask for everything. 2. At the exact same time, ask for that disclosure log we just talked about. 3. If they start to drag their feet, you gently but firmly remind them about that 45-day deadline. 4. If you find something that's wrong, you formally request to amend it. And 5. If you hit a brick wall, you just calmly escalate it up the chain of command. And to make this even easier, here's some actual language you can use. See how it's simple and direct? It kicks off by citing the law, pursuant to FERPA, which immediately shows them you know what you're talking about. And it asks for all records, which is so important for getting the full story. This kind of professional, non-confrontational approach is almost always the most effective way to start. And here you go, the specific language for that powerhouse tool, the disclosure log. Using a phrase like record of requests for access and disclosures mirrors the exact wording in the law. This sends a clear signal to the school that you understand their specific duties, and you expect to get a complete log of who's been looking at that file. So what happens if you find an error? Well, you have the right to request an amendment. You can use language just like this. The key here is to be incredibly specific. You need to state exactly which part is inaccurate or misleading, explain why it is, and then tell them exactly what the requested amendment is. This isn't about arguing over opinions. It's about correcting the facts to make sure the record is true. All right, before we wrap up, let's do a little myth busting. We need to tackle some of the most common things schools say, sometimes by mistake, to block your access. It is time to separate the fact from the fiction. Myth number 1, and oh man, this is a big one. The idea that a non-custodial parent is just automatically blocked from seeing records. The fact is, under FERPA, both parents are on totally equal ground. A regular custody agreement isn't enough to block access. You need a specific court order that explicitly says you no longer have FERPA rights. Next up is the email excuse. Oh, we can't give you those. They're just emails. Well, not so fast. If an email is directly about a student and the school is maintaining it, meaning saving it as part of that student's official file, then it absolutely can be an education record and you have a right to see it. And finally, let's talk about the money myth. Now, a school can charge you a reasonable fee for making copies of records, but they cannot charge you for the time it takes them to search for and retrieve them. And even more important, the fee can never be so high that it actually stops you from getting access. Your rights can't be priced out of reach. So there you have it. FERPA isn't some barrier designed to keep you out. It's a blueprint. It's a set of keys that gives you the right to see, to correct, and to control your student's educational story. The only question left is, now that you have the keys, what door are you going to unlock first?